Okay, let's go ahead and get this started. Again, my name is Kara Maciel. I'm chair of the Labor and Employment Practice Group here at Maciel Carey. Welcome to the Mitigating Cybersecurity Risks to Your Company's Confidential Information from Exiting Employees webinar. We hope to be able to have some time at the end to address questions, but if not, either Darius or I can follow up with you individually following the program. Thanks again for joining us, and we hope that you enjoy today's program. As I mentioned, I am Kara Maciel. I head our Labor and Practice Group. I do everything soup to nuts, from advising employers on policies and procedures to counseling on internal investigations. And then, of course, I also defend employers in litigation at the federal and state level, particularly including claims that we're talking about today as relating to trade secret misappropriation and breach of non-disclosure agreements. With me, I have my colleague, Darius Rohani Shukla, and I'll let him introduce himself.
Hi, everyone. My name is Darius. I'm an associate here in the DC office of Maciel Carey. I work with both the labor employment side and the OSHA practice groups, where I'm involved in all aspects of labor and employment law, including restrictive covenants, wage and hour disputes, data privacy issues, claims of discrimination and harassment, as well as compliance with the ADA, FMLA, and general employment counseling and anything we can help with. We enjoy, kind of like Kara said, I really enjoyed litigating these cases, particularly involving trade secret and Computer Fraud and Abuse Act, as well as non-disclosure agreement breaches. So looking forward to presenting to you all today.
Thank you, Darius. So with that, we'll just kick it straight off. I'm going to cover kind of trade secret management at the outset. A couple of surveys have been done recently, and I think this is pretty interesting. So what do senior executives in the United States consider to be some of the top threats to security, to trade secrets? About 24% thought that corporate espionage was a top threat. Then we went to third-party service provider risks, then competitive intelligence at about 27%. And then you'll see that it really jumps to almost half of the recipients thought that employee leaks and weakness in cybersecurity were two of the top threats to their security, to their trade secret information. And we'll be talking about both of those types of threats and what employers can be doing strategically to address and try and mitigate against those two types of threats. The survey also talked about what are some of most effective practices for preventing potential threats to trade secrets. The most effective, of course, is installing computer safeguarding and cybersecurity software. So this could be anything from a tool that can be installed that will automatically flag any type of downloading of data, any type of file transfer to an external email address. If you have, if you allow people to download things to a USB drive, those types of flagging. Anything from tools that can analyze data after people return their computers from an exiting employee. So a lot of different types of software and forensic tools that you can install to help mitigate and prevent thefts of trade secrets. Also, confidentiality agreements and policies is a very effective tool, right? It's something that we use routinely in litigation, as it allows for a claim of breach of the contract if someone is misappropriating trade secrets or not following corporate policies with respect to your security and electronic use policies. Restricting digital and physical access to documents. And we'll talk about this, but certainly it's important to make sure that the people who need to have access to trade secret information have the access, but that it's not widespread access across the company. You want to make sure you are limiting and locking the door like you used to have the proverbial key in the file cabinet. You're doing the same thing with your digital and electronic devices, where people can access certain databases, how they can access information. You want to make sure that that is locked down to those people who need to have access to it. Kind of a novel new area is introducing a culture with incentives for trade secret protection. whether that's through economic incentives or other type of incentives to make sure that your senior leaders, those that are tasked with protecting the trade secrets, IT, HR, legal, compliance, that they are incentivized in making sure that that is being done properly throughout your organization. And then finally, avoiding cloud storage of important trade secrets. We'll talk about how easy it is in this age of technology and remote work, how easy it is for someone to just download things to a USB drive, upload them up to the cloud, and they're stored, and how those can be transferred in and outside of your organization. And so think about maybe that if that is a practice you'd want to consider implementing to protect your trade secrets. But really, at the very beginning, when we're talking about trade secret management, there's 4 stages that you want to think about when you are talking about trade secrets. And it's something that should be done regularly. It's not a one-time, one-size-fits-all, okay, let's just label this as a trade secret and move on. It's really something that we encourage companies to analyze regularly based on your corporate structure and what industry in, and what are your products, what are your services. Is it an R&D issue that you want to protect, or are you more focused on SOPs or other types of information within your company that you want to value as trade secrets? So the first thing you want to understand is these really stages, you can't juggle them around, right? You want to target your efforts and focus on the most meaningful trade secrets within your organization, because that is what a court is going to look at. If you ever have to get into court, seek an injunction to protect the misappropriation of your trade secret, you're going to need to be able to explain very clearly, very simply to someone who may not know anything about your business or your products or your services, why this information must be protected and why an injunction must be ordered immediately to avoid undue harm, irreparable harm to your company should it be lost or stolen. So the first stage is identifying it. And I'll go a little bit in more detail each of these stages, but the first stage is identifying the trade secret. What do you want as a company? What do you want to protect as your trade secret? Secondly, you want to then classify them in categories so that you further can detail and have methodologies for how you further protect that trade secret. The third stage is then protecting those trade secrets. What steps, what things are you doing, putting into place, what procedures, things we just talked about, security, how are you securing and protecting that information so that it doesn't get in the hands of people who shouldn't have it. And then finally, how do you value that trade secret? It's important when you go into court that you're able to demonstrate that that trade secret has economic value to you, that if it gets in the hands of the competitor, would be harmful, would destroy your business, have an economic cost. And so you want to be able to, from the outset, be able to value that trade secret before there's any type of misappropriation. So let's start with identifying trade secrets. This is a very fact-specific inquiry. You've got economic value that I just talked about, security risks. All of those vary by trade secrets, even within an organization. Something that you may be developing in your R&D may have a very different value for you this year than maybe a standard operating procedure that you developed 3 years ago. And so it's very important that you understand and have the right people on board identifying which are the right type of trade secrets for their department, their unit within your organization. Generally, the courts consider these 5 factors, and these stem from the Uniform Trade Secrets Act, which generally applies across the country. It's a federal statute. They're also every state, I would say most states, I don't know if every state, but almost most states have adopted the Uniform Trade Secret Act. So if you're in Missouri, there's a Missouri Trade Secret Act, and they have similar factors. So you can get it when you get into court, you have an opportunity to seek both federal claims and state claims. So the first factor is whether the information is known outside of your business. Obviously, if it's something that is readily available on the internet, then that's not something that's a trade secret. It's not secret. So if it's got to be held within your company that others outside of your business do not know about it. That you have taken measures to guard the secrecy of the information. That Is the information password protected? Do you secure your building by a key card? Do you, only give a laptop to or electronic access to certain individuals who need to know the information? How do you guard it? Do you label the document confidential, trade secret, proprietary? Think about physically and electronically labeling that information so that someone accesses it, they know immediately you've identified this as a trade secret. What is the value of the information to the owner and to the competitor? Something we'll talk a little bit about, but you really want to think about it. If my competitor got this formula for developing this product, what would they get from it? And what would I lose as a result of them having it? Would I lose business? Would I lose competitive advantage? Would I potentially lose customers? You want to think about the amount or effort, money expended by you in developing that information. Who did you have to hire to develop this trade secret? How much money was spent in creating this product or this service? What type of development opportunities can you quantify, that amount of money, the time and effort that was spent throughout your organization? And then finally, how easy is it for someone to duplicate it or reverse engineer it? If it's pretty easy to do so, that minimizes the value to your organization. But again, it goes back to sort of all of these factors. The amount of time and effort that you've spent in developing this information should make it difficult for a competitor or a hacker or a bad exiting employee, to be able to reverse and reuse and use this information by others. The second stage is classifying your trade secrets. So once you've identified very broad brush, okay, these are the types of information that I want to identify. Now I'm going to classify them into buckets. You want to think about how you would articulate the value of this information, like I said, to a third party or most likely to a judge, so that the judge can understand. When you're going into court, often on a misappropriation of trade secret claim, you're seeking a temporary restraining order, which means your lawyer usually can go in very quickly, often ex parte, without the other side coming in. Sometimes the lawyer's standing in the judge's chambers and saying, Your Honor, today, right now, I need you to make sure that this formula doesn't get in the hands of my competitor because it will be devastating to our business. So you want to be able to do this very quickly and in advance of any potential misappropriation claim. So think about these types of classifications, right? Do you have customer lists that are secret? Do you keep your customer names secret within your organization? What would happen if your competitor knew who your customers were and how you prioritize certain customers? Which are your top customers, your most revenue producing customers? Marketing plans. What is your strategy in business? What are you doing in the future? What are you doing today? And how much money have you spent to try and market your company to stand out from your competitors? Strategic business plans. What are your key performance metrics? What are you thinking about doing in the next year, 5 years, 10 years? That would give a roadmap to your competitor about where you wanted to go, what markets you want to be entering, what markets you may want to be removing from, where you're putting your money in the future would be invaluable to a competitor. If you are a company that produces products, how are those products tested? Are there particular dates, things that are not known outside of the organization? Certainly pricing information, formulas, manufacturing process. I mean, the typical R&D that you think of, what's the secret formula for Coke? That type of stuff is clearly trade secrets, but very common in the manufacturing processes. But even, outside of that, research studies, training manuals, things on here, standard operating procedures. If you are developing time and effort in a unique standard operating procedure for your company that no one else would know, that if a competitor got it and it would make their processes more efficient, be able to maybe get up to speed faster, or even a startup company. If a startup company had all of your standard operating procedures, it would give them a leg up much faster than if they had to develop these operating procedures on their own. So really at this stage, you want to be thinking through where your trade secrets are and classifying them throughout your organization. Interestingly, as I mentioned, there was a study in 2021 by the Economic Intelligence Unit, and 13% of the senior corporate executives who were surveyed identified the failure of their organization to categorize intangible assets as a significant threat to the security of the organization's trade secrets. So just what we're talking about right now, the importance of categorizing the assets that you have. 22% responded that one of the biggest obstacles to safeguarding trade secrets is the difficulty in defining what they are. And then 28% of them identified a lack of in-house experience or awareness about trade secrets as a major impediment to protecting trade secrets. So really making sure you have key leaders in your organization, whether it's in your legal department or it's in your compliance department, or it's in other areas that really are able to come together and work collaboratively as a team to identify what those trade secrets are. The third stage, is protecting your trade secrets, right? So there's a lot of things that you can do, and we'll talk about this throughout our session today, but you want to make sure employees know what information is confidential and what their obligation is to keep it confidential, both during their employment and after their employment ends. So there should be, a employment agreement or a standalone non-disclosure confidentiality agreement that explains their duty to maintain confidentiality. Consider restrictive covenants on solicitation of customers, solicitation of employees after they leave the organization, and most importantly, their duty to return confidential and proprietary information upon exiting. This is one of the biggest things that we see in leading to litigation and in internal investigations of theft of misappropriation trade secrets. Sometimes employees, they don't know what they're doing. They stick in a USB device into their laptop because they need to use a printer or they're traveling and they want to have access to it. And then they forget that they had this USB drive and it's sitting in their home or in their car, vault or wherever it is, not realizing that it's out there and it has information. Other times, employees, same thing, I want to look at some of these documents. I'm going to email myself at home or my personal email address. I'm going to email things so I can access it at home. Other times, people intentionally do that. And so you want to make sure that when someone is leaving, you are not only getting all of their information that they have on their computer or in their office, but anything that could be on home or personal electronic devices that you don't have control over. And that in those agreements, you make sure that you put in a requirement that they must give you access to that information to wipe it out, delete, permanently remove that information from those devices. During people's employment, you want to make sure that you are protecting information through passwords, maybe multiple level of passwords, right? Someone can come in and maybe have access to this database, but there's another password for this narrow database with more confidential information. You prevent anti-deletion programs so people can't intentionally delete information from your computer system. And as I mentioned earlier, both marking documents as confidential and proprietary, or even trade secret, depending on how many levels you have. You might have confidential, which is sort of a yellow level. You might have proprietary, which is an orange level, and then trade secret, which is, really, really red level, high level security. Do that both in hard copy, but also electronically. Another way to protect it, right, as we talked about, limiting access, limiting document circulation really to people on a need-to-know basis. I mentioned this earlier, you want to periodically assess the categories of trade secrets because your business and strategies grow and develop and change. What might have been a trade secret yesterday or a year ago isn't going to be a trade secret tomorrow or next year. Vice versa, you may be developing a new area and you want to make sure that you're not letting those fall through the gaps as you're developing that information. Do an annual refresh and training on all of your employees on your policies, on the expectations of protecting your confidential information and the expectations of maintaining confidentiality after they leave. And when done, when documents are to be disposed, make sure that those are done completely. So there's no way that they could be reformulated, particularly electronic documents. It's easy to put something in the trash, but that doesn't necessarily mean it's permanently destroyed. So you want to make sure electronic documents, to the extent you want to, are permanently deleted from your system. And then the final thing that I want to talk about before turning over to Darius is how to value your trade secrets. You want to think about 4 different types of associated issues. First is the associated costs, right? So this is the economic outlay that you've used to create or develop the trade secret. That can include anything such as the time that was taken to develop the trade secret, the time taken to test it, labor costs that are involved, some investment in your physical capital, like equipment or property, any other kind of related expenses. Think about economic outlay to provide protecting that trade secret. So that could be your administrative, your legal, IT, technical protections deployed to keep that trade secret safe over time. Another value is the associated timing. And this is the anticipated protection period as impacted by the likelihood of a competitor discovering through either reverse engineering or other proper means your trade secret. Obviously, you may decide to declassify the trade secret over time for a variety of reasons. And so think about when you're going to do that and what is the value over time. Associated benefits include the economic benefits that are expected because of the trade secret's use in a product or service, such as greater sales, you're increasing revenue, you were able to develop a new product that you can sell to the market, or maybe it's a cost reduction. You're able to be more efficient in some of your technology or your products or your services, and as a result, be more profitable. And then finally, the associated risks, right? So this is the risk that you put by failing to treat the information as a trade secret, by either not controlling access or not putting reasonable protections in place, the risk that the trade secret is misappropriated by a disgruntled employee, a former executive or senior level executive, a competitor, or even a hacker. The risk that, an independent party somehow publishes the information so that now it's in the public domain accidentally. Obviously, all of these economic considerations are relevant for valuing your trade secrets, and having access to this information will be important to understand and articulate, again, how you're in court, how your company has valued the trade secret for protection. And with that, I'll turn it over to Darius to talk about identifying cybersecurity risks.
So a really important first step in protecting any trade secrets that you desire to protect is really identifying what risks are out there. One of the primary risks to maintaining company confidential information to maintaining company confidential trade secrets are your employees. Given how intertwined technology is in most employees' everyday jobs, insider threats, whether sort of intentional or accidental, are a major consideration when assessing cybersecurity risks. Let's see. Employees can attempt to sort of take or expose company data and information such as customer lists, trade secrets, etc. And those actions can obviously expose competitive intelligence and also raise obviously significant confidentiality concerns. Interestingly, like the vast majority of employee data breaches and sort of instances of trade secret theft aren't necessarily financially motivated. So while it's like an obvious and considerable motivation in many instances of employee data theft, there are other motivations that you might want to consider as well when you try to analyze your potential risks. For instance, competitive advantage related to sort of a financial motivation, but not necessarily completely aligned. And that sort of ex-employees might steal intellectual property just to gain favor with a competing company. Some employees are just vengeful. They might have been terminated, denied a raise, or passed over their promotion, and as a result, might be likely to steal corporate data purely as an act of retaliation. Some employees might feel entitled to corporate data theft. They might feel that they had a hand in kind of developing something like a source code, and as a result, it is theirs to take. Or they might feel they're so valuable to the company because of their work, they're entitled to take this with them. Similarly, and kind of on sort of the most straightforward perspective, like profit is, still, while it not be the primary motivator, is a motivator for some employees, and that they might attempt to sort of directly steal from the organization, exfiltrate data that might have monetary value, or sort of in the more cynical aspect, just deploy malware in exchange for a ransom. So the list of indicators kind of on this screen really suggests the personality or headspace of an individual who might be a concern to your company, or likewise sort of demonstrate a specific warning sign that an individual who's sort of in the midst of stealing company confidential information might portray. Sort of the disgruntled employee, the poor employee is a poor performance rating, an employee who is chronically expressing that they've been under-recognized at work. You can see how they might fall into this sort of like vengeful category. Likewise, an employee who keeps saying they're above the rules at work, routinely goes to executives and bypasses supervisors, failing to follow the chain of command. You can see how that might align with sort of someone who certainly feels entitled at work. And likewise, employees who are committing security infractions have unexplained affluence, considerable or unusual foreign travel. They're coming to work at sort of obscure hours. On the most blatant example, they're excessively using copiers, scanners, faxers to transmit information, and you're not sure why. That might suggest that the individual is like specifically in the midst of trying to steal company trade secrets or confidential information. So this is sort of a list of technological indicators that companies can look for that'll really demonstrate, the probability that there is a threat of your company confidential information being exposed through some sort of technological means. This list, what it does is really highlight the inappropriate or kind of unauthorized uses of that information technology that could lead to or really be evidence of some type of insider threat. What you'll notice sort of when you look at this list is that it's effectively like the technological manifestation of the indicators we just discussed. Looking at this first instance, increased non-business related activities on the internet. I mean, an employee who is surfing the web, job hunting, using social media, sort of demonstrating that their work, and by extension, really their loyalty to the company, isn't as much of a priority as it was before. If IT can sort of pick up increased foreign IP traffic, that individual is suddenly in contact with a foreign IP address that on a very basic level that they weren't before. So it demonstrates that the individual is communicating with someone new, and this could be intentional. They're nefarious and they're directly communicating with a new entity to transfer information, or it could be entirely unintentional. They've sort of been phished, and this is indicated that they believe that they might be think they are communicating with some sort of vendor that is entirely that they believe is harmless, when in fact is someone sort of actively trying to steal confidential information from your company. On this sort of more blatant examples of an insider threat from the technology perspective, if someone's using increased email and USB storage transfers, it demonstrates that they're specifically transferring information outside of your company. And if it's sort of a marketed uptake that doesn't really correspond with their job responsibilities, this suggests that it's transferring company information outside of the company, unrelated to their job duties. For insider threats, as I mentioned, it doesn't always have to be the nefarious sort of intentional individual who is vengeful. If an individual is repeatedly falling for phishing attacks, they are still a severe risk to your company, because that means that they could be giving up usernames, passwords that are used to protect confidential information and expose it to attackers that are attempting to gain access. And importantly, with sort of phishing attacks, they might not be aware they've done it. Maybe they've realized that they responded to two, but if there's one phishing attack that they didn't realize that they responded to and no one is aware of it, including your IT, that information might have been transferred to a nefarious third party and no one is aware of it. Individuals who will sort of post sensitive information demonstrates, again, one, they could be sort of resentful or entitled and feel like they can do it and they want to, disparage your company, or they're just careless. They're putting sensitive information, not realizing that they shouldn't do so, and because they're not following company policies, they haven't read the company policy or they're not aware of it. Individuals who sort of, kind of are conducting unexplained network or company database searches or attempting remote access after being laid off or terminated, they're on a very basic level attempting to obtain company information that they have no need for due to one, sort of their job responsibilities or their lack thereof job responsibilities if they've been fired. So this is a strong indicator that they're attempting to steal company information that by definition they have no access to, which typically means they're going to be trying to attempt to get that information for some sort of nefarious purpose. And most importantly, sort of in violation of the company's policies. And then finally, again, when an individual sort of encrypting emails to private or personal accounts, this is demonstrative of the fact that the employee, is attempting to hide something, which a well-to-do employee should have no need to do. So when you're sort of looking at insider threats, this is sort of a framework you might consider in terms of how you want to, sort of just from a very broad, 1,000-foot view. A framework is that, there's sort of three types of threats that you can consider. They're not mutually exclusive by any means, but a way of looking at it, right? This is really why anybody would want your trade secrets or confidential information. One, they're a thief. They want the intellectual property for profit, start their own business. Kind of tailing with that, they're a competitor. They want to compete with you in a marketplace and sort of require your confidential information, be it, how you conduct your business or sort of who you conduct your business with, who are your sort of customers. And then finally, they're an adversary, an individual or company sort of seeking to harm you for effectively the sake of doing so, right? They want to get you out of business. One issue that can really magnify the risk of potential cybersecurity threats is when companies really conduct downsizing or layoffs. So downsizing and layoffs place resource constraints on an organization. If there isn't sort of proper planning in place, if you shed certain positions, there might be less checks and balances in core areas across, say, the company's IT, company's management, and the human resources functions. If there's a lower headcount in IT or other tech-related departments, that might create gaps in sort of supervisory coverage and might make a company more vulnerable to cyber threats. Likewise, terminating employees with oversight responsibilities could affect kind of the proper management of access to repositories information, databases, confidential materials, and again, potentially creating vulnerabilities if these sort of repositories of information aren't being adequately maintained. So it's really vital that when there are layoffs, downsizing, or as I'll go into later, just specific employee terminations, that IT, HR, sort of individuals that are in charge of intellectual property and trade secrets coordinate and they're on the same page, and that there's really an emphasis on continuity and maintaining the confidentiality of your information. In terms of sort of specific employees, companies might also be wary of how they terminate specifically valuable employees who have specific access to confidential information. You might have gone through all the steps of layering who has access to information, but still, once upon a time, there might come a time where you want to sort of terminate a high-level employee with access to significant amounts of information. If that sort of individual is being terminated or scheduled to be terminated, it's helpful that all the sectors I previously mentioned, IT, HR, individuals in charge of intellectual property work together again beforehand to make sure that the specific individual's access to sensitive information is monitored sort of beforehand and then removed at the appropriate time so that the individual can't take electronic or physical information the company doesn't want them to have access to after their employment. So that's sort of how do you kind of identify the risks that you might be posed to your company on the physical and sort of cybersecurity front. So the next stage is kind of considering how do you mitigate them? How are you proactive and get ahead of them? While a lot of information is stored digitally, physical security is really important sort of from two perspectives. One, physical security in terms of your documents themselves, but as well as the fact that employees might have hard copies of one company data, but two, usernames and passwords for the accounts where sensitive information might be stored on sort of a more broad basis. So if security from a physical perspective isn't maintained properly, all the safety measures in the world in the cybersecurity front might be less valuable. An adversary can simply walk in, sort of the metaphorical or physical front door. So these are kind of a few suggestions of what companies might consider as part of a plan to sort of really maintain physical security for their workplaces, and as a result, trade secrets and confidential information. So video surveillance, after-hours security monitoring, suspicious behavior reporting system, and logs of facility access, restricting recording or photographic devices. These are ways you can sort of monitor, excuse me, your employees themselves, as well as sort of potential adversaries that might be attempting to gain access alike. Similarly, employee ID badges with control access and really like locking restricted access is a good way of ensuring that confidential information and trade secrets are maintained on a need-to-know basis in your physical workplace. And importantly, you can sort of track the life cycle of a physical document if you're careful by, you mark your sensitive documents, you keep an inventory of who has them, where they are, and you ensure that they're disposed of properly so that you know that they can't pop up on the internet after you've disposed them and they're not, they're being shredded appropriately and not in the wrong sort of trash can effectively. So having it, and then importantly, in terms of, like you mentioned before, terminating employees, there's a physical perspective of this as well, having physical, a physical plan in terms of what to do when an employee is terminated so that the employee who's terminated and as a result might be disgruntled can't grab a box of sensitive documents, grab just one important sensitive company document on their way out. So you might consider escorting an employee out, taking their items out to them, so making sure that they don't have access to confidential documents from a physical perspective after they're terminated. The second, aspect of sort of mitigating your risks is the cybersecurity front. Obviously, most, if not all, for some companies, business information is in fact stored electronically. So it's important that there's a secure approach to sort of protect information from hackers, as well as employees themselves to protect trade secrets. So these are a few additional kind of considerations you can have to sort of restrict and monitor access to your electronic information, and as well as that sort of good, like proactive cybersecurity hygiene measures that you can do to make sure that you're usually on good footing and maintaining the appropriate measures in place, even before an employee is being terminated or before you have some sort of risk that has popped up. So along those lines, like maintaining computer event logs, dates and times of who's logged in and who's logged out, when and where, what files and networks have been accessed, allows you to be sure that employees are accessing the appropriate files at the appropriate times. Maintaining routine password changes, if it's good hygiene so that an employee's password is routinely being updated, it makes it less easy for that password to sort of be accessed by some sort of third party or adversary. Quarantining emails sent to large numbers of employees or company executives is a good way of sort of getting ahead of maybe potential phishing attempts. Providing employees with clean laptops or external devices when traveling mitigates the risk of an employee who has confidential information on their laptop accidentally being somewhere new and either plugging into the wrong Wi-Fi, using the wrong Wi-Fi that might accidentally provide access to a nefarious party, or accidentally using a USB device they shouldn't be using. Or sometimes in some instances, plugging into charging stations can also be a cybersecurity risk that could cause a laptop to be exposed to a third party or nefarious party. Tracking and limiting data downloads from company computers, right, is vitally important because it enables you to ensure that your data maintains on company computers. Requiring multi-factor authentication for computer access is an important sort of cybersecurity hygiene to ensure that employees' usernames and passwords are only used by those employees and not hacked by any, again, adversary. Likewise, limiting remote access to company's computer network makes it more difficult for employees to get onto the computer network when they're outside of the company's physical place or if they're on a new device. A few other sort of factors to kind of consider are limiting access to unauthorized websites or social media accounts. You can, vitally decrease the risk that confidential information is publicized if employees don't have access to websites or social media accounts when they're on the computer that has that confidential information. Maintaining antivirus and malware and anti-malware software is really important, as well as that making sure that your IT department is considering this yearly. Make sure there's sort of an annual checkup to make sure that these antivirus and malware softwares are up to date. Having a suspicious email reporting system in place is helpful because it means that there's a way for employees who get suspicious emails to report them up. Maybe one employee noticed the email, but another employee didn't. If no one has a way of reporting it up to IT or management, maybe that employee doesn't report it and the risk goes sort of unmitigated. But if one employee spots it and can sort of alert the company to it, it makes it easier for a company to respond as a result. Digital watermarks and fingerprints are a great way of tracking electronic files that you might want to be trying to ensure don't end up in the hands of adversaries, various third parties. And finally, having an intrusion attempt or cyber attack plan enables you to be prepared. So if you find out that someone has got into your network, you're prepared, and kind of along lines with number 13, you know where your access points are, who to sort of communicate with, and you're not starting from square one at a time when you want to be responding as soon as possible. When you're sort of dealing with all these potential ways of mitigating your physical and cybersecurity risks, it's really important that you provide training to employees and managers alike, so they sort of really know what is expected of them when handling this information. As Karen mentioned, training is so important with making sure that employees and managers know what the information is, and really in this instance, sort of what is expected of them in protecting it. What practices should they be following? What is inappropriate when you're traveling? What is appropriate? The reason being, if employees and managers aren't following these procedures, some companies might not be able to, on sort of the legal perspective, demonstrate a potential lawsuit that the information was a trade secret if it wasn't sort of being adequately protected in the first place. But on a more sort of practical perspective, if employees and managers aren't being trained on the exact procedures that the company has in place to protect the information, then practically it isn't really being protected. So training is how you sort of is a great way of transferring the company's sort of planning from an HR, IT, and IP's perspective down to the employees, so that the entire kind of business is protected. In terms of the previously mentioned incident response plan, it's important to kind of companies consider what they want to do if an incident were to occur. Sort of outline the steps that need to be executed in the event of some sort of intrusion or some sort of theft of IP. Companies might consider sort of forming some sort of threat management plan led by senior management to address potential issues. That way they know sort of they can coordinate with IT in terms of how much of the network needs to be shut down, quarantined, or isolated, if at all. Because perhaps the incident might not involve shutting down the whole network and potentially kind of hampering business operations. Importantly, there needs to be someone in place who can document who discovered the theft or intrusion, so that when the investigation comes back after the fact, an appropriate investigation can take place. It's important that the incident response plan identifies the information that's been stolen immediately to identify the risk to the company, and that all sort of relevant security activity in terms of who was logging into the network at what time is secured or archived, so that it isn't sort of deleted as part of some cycling. Some companies will only store relevant network security for a limited amount of time. If that information is deleted, it's going to be difficult, again, sort of identify and investigate what exactly occurred, and if if theft is still ongoing. So as I mentioned, there's a very acute risk of trade secrets being exposed from departing employees. So in doing that, there's a few steps that are important to keep in mind of how to mitigate this risk of departing employees specifically. First step of that is really conducting a robust exit interview process. And what that means is establishing a plan of a thorough exit interview process, so employees organizations can really confirm on the record that an employee hasn't sort of inappropriately retained company information, isn't aware of other breach or cyber incidents that haven't been disclosed or handled. And it's also a way sort of for the company to rehash exactly what the employee's duties and oversight responsibilities are, as well as sort of where the employee's work product has been stored, so everything's accounted for. So in terms of sort of a game plan and looking through this, first you want to make sure that you collect all the company's issued property, and that's a good thing to confirm with the employee during the exit interview, and then maintain a chain of custody for all returned computers. You want to sort of again, as part of this exit process, make sure that employee access to the computer network, email, and servers is cut off. Ensure that sort of all accounts are removed from employee devices if they are using their own specific devices to access the company's information. Be wary and sort of consider cloud access and websites that might be accessible through company usernames and passwords after the fact. Make sure that all usernames and passwords are effectively cut off. Make sure that, if an employee has a hard drive from the laptop and desktop that is secured and again, not reissued to the employee. Conducting an inventory of the hard copies of files that the employees have, as well as the electronic files. And if an employee is, moving to a competitor, a smart and proactive step is sort of to contact that new employer and notify them of the employee's obligations, under their employment agreement in regard to what information is a trade secret and confidential and cannot carry through with them from their previous employer to their future employer. And then importantly, while you have the employee, while you're conducting this exit interview process, you can just as easily have the employee attest to their continuing obligation and make sure that they sign indicating that they are aware that they have obligations and sort of maintain the confidentiality of company trade secrets. They have duties not to disclose, duties not to solicit, and also attest that they returned all company information and company equipment. I've sort of referenced a few times sort of the obligations that employees have regarding their confidential information when they move from one employer to the next. And it's relatively straightforward. It's effectively, employees can use what's in their head when they move from one employer to the next. They can use their general knowledge, their skills, their experience, that's there, it's in their head. But what they cannot use is, confidential information or trade secrets that are acquired during their employment, information that is proprietary to their prior employer, taking that to their future employer. And then another instance that I wanted to kind of delve into a little bit further is keeping track of devices. An important policy that employers can put in place and also consider with exiting employees is device tracking. It's really important that companies sort of create an inventory as a first step of all the devices that an employee uses and possesses. There'll be company issued devices as well as bring your own devices that employees' personal devices using their own phone to access the employer's company email. And so in doing so, you want to sort of establish a procedure for collecting and wiping devices once an employee leaves the organizations. For bring your own, for a BYOD equipment, there is sort of kind of technology that employers can use to sort of separate and encrypt company apps and data so that IT can manage the security of company information on an employee's personal information once that employee leaves and sort of remotely wipe the data when the employment ends. Whatever sort of method organizations use, it's really critical that basically you account for all the devices an employee has sort of that are connected to the company, be it company issued, be it their own personal device, and ensure after the fact that sort of all company data has been returned, returned or deleted sort of at the conclusion of that employee's employment. I'll move it and I will let Kara explain kind of the steps in terms of how to respond to what happens if there has been any sort of trade secret theft or covering confidential information.
Great, thanks, Darius. Okay, so what happens if you find an issue where someone is trying to download or take your information? So a lot of things Darius mentioned, but these are some key steps to investigate potential theft of your confidential information. You want to look at your backup tapes, securing those tapes, drives of emails and network servers so that you can ensure that you've got what someone might be trying to steal and it's not somehow deleted through your regular retention policy. You want to develop an internal forensic protocol for searching those backup tapes and drives, doing it in a way that you are protecting any chain of custody in the event that this investigation has to be used in litigation. So you want to ensure that the individuals that are doing it are trained, they're following industry standards and protocols. If you don't have anyone internally, highly suggest you hire a third-party forensic company to come in and help you with that protocol so that it can be ensured and preserved should the event that you need to introduce this evidence into court, either for securing a trade secret, a TRO, or a preliminary injunction. Those individuals often may need to be witnessed to ensure that you have the right type of protocol. Treating these kind of allegations as confidential, so making sure that only who needs to know is involved in the confidential investigations. Again, avoiding invasion of privacy. You don't want to somehow trip up the individual who may be accused of theft of confidential information through their privacy. So there's a lot of other ways that you can also, investigate theft of information through technology. I think a lot of theft right now that I'm litigating and I'm advising on does involve some type of technologically based information. So those sources, right? You want to make sure you're keeping it very broad, your investigation. You're looking at someone's personal computer. If they have a desktop or a laptop, they're returning their work computer when they're exiting, and you are evaluating it, you are imaging it, you're copying it, and you're making sure that that is preserved for investigation. Looking at email, has there been a history of this employee emailing information to their personal account, or is this something that's happened in the last month or a few weeks leading up to their termination or resignation? Looking at voicemail, looking at phones. Did this person take photos using the company phone of whiteboards or of documents, or did they take videos of the manufacturing process or things that are happening, equipment that is used, or highly sensitive information? Look at telephone dial in and out records, card access records. Where was their movement within the building, and what are they accessing? That's where video surveillance cameras can help as well. And as I mentioned, cell phone records. You want to have, an immediate response. You want to make sure you are, following the incident response plan that Darius had mentioned, conducting your investigation, preferably under advice of counsel or with counsel, either in-house counsel or outside counsel, so that that investigation is protected and can be used effectively going forward. And then you want to do whatever you can to preserve your trade secrets. So if you need to go into court seeking injunctive relief, either under your ability through your employment agreement, or you can use the Defend Trade Secrets Act, state version, also the Uniform Trade Secrets Act. There's also civil suit remedies that you can pursue if they've, converted your property. That's conversion. They come on your property to steal it. That's trespass. Breach of contract is an easy one to assert. Certainly, if you've got restrictive covenants in there, confidentiality obligations, non-disclosure agreements. The Computer Fraud and Abuse Act is a federal claim that often can get you into federal court, in addition to the Defend Trade Secrets Act. And oftentimes you want to be in federal court in these kinds of cases. Federal judges often act quicker, possibly, and are more knowledgeable about these issues than a state court judge. But the Computer Fraud and Abuse Act is if you have an employee that returns their laptop and you notice that data has been wiped, or the whole computer has been wiped, or you see emails or documents have been deleted from the network or server, and that was done after they knew about their termination or after their employment ended, that could rise to a claim under the Computer Fraud and Abuse Act. So before I close and I want to open it for questions, I want to talk about a couple of practical steps for you to take. Certainly, I think it's been repeated and it bears repeating. Really important to make sure you've got employees signing a confidential information agreement upon hire. Have it drafted, have it reviewed annually to make sure that it is, it's lawful in your state, it's lawful under the National Labor Relations Act, but certainly you are able to have employees sign documents that protect your confidential information and trade secret information. Then do annual training to define what those confidential obligations are. Make sure people attest that they did this training, reminding employees of what is confidential, including the social media awareness and cybersecurity threats, remind employees what they can and cannot do with information, that they can't send things out on a USB drive, that they're not authorized to send things to a personal email address. Those annual trainings can be very useful to demonstrate that if the employee knew what their limitations were and where their authorization stopped. And if they exceeded their authorization, they did so intentionally, knowingly, without permission. You want to take physical measures to restrict access to those with the need to know, whether that's, badge passing, sign-in logins for visitors, passwords, limiting access, limiting USB drives. And then finally, you want to really think about, some targeted training for personnel at specific exposure points. If you are in the manufacturing business, looking at your good manufacturing practices, people that are in sales, who have access to customer lists, customer names, invoicing, purchasing, revenue history, key performance indicators. Also, people that are doing R&D, strategic planning. Think about having targeted training for each of those. As Darius mentioned, when someone is leaving, making sure that they sign a statement or an affidavit that they have returned all company information, not downloaded any data to personal devices and files, and that you can collect those assets immediately upon departure, wiping where needed, getting access to email addresses if necessary, to make sure that those emails have been permanently deleted from their email system. Launch IT forensics either internally or externally when you have a key level or high level access departing employee, if they're going to a competitor. And then certainly respond promptly to any idea or notification that possibly your information is being misused. And so that really wraps up what Darius and I wanted to share about some practical things you should be thinking about to protect your confidential proprietary information and trade secret information, and what to do in the event that you have an exiting employee that may be taking something inadvertently or innocently, or certainly not so innocently, what you can do next. Know that we are having your 2024 employment webinar series is out. We have a webinar every month. Next month, we'll be talking about employment law compliance in ESG programs. So that's going to be a good one. But please take a look at the rest of the calendar year, and please sign up and register for those that you are interested in. Check out our blogs. We always post regularly on timely issues that are affecting employers, from labor and employment issues to OSHA issues, California OSHA, and our MSHA defense report. This is information about our California Workplace Violence Compliance Solutions Program. You can scan this QCR code for more information. And hopefully everyone enjoyed and learned something, or able to take something practically back to their workplace. Okay, well, right at the top of the hour. So thank you everybody for joining us. And don't hesitate to reach out to either Darius or myself if you have an issue and would like some more specific advice. Thank you.